Hello everyone, and welcome to Chapter 4. Chapter 4 covers a couple different things, but the focus of my video lecture today is going to be on the pre-sentence report. The pre-sentence report it's a very important document. It's used by many people throughout the criminal justice system. Its primary use, and its most important use, if you will, is for the court system. The judges use information from the pre-sentence report to determine an appropriate sentence. Now, the pre-sentence report contains a tremendous amount of information. So I'm going to go over a little bit about that. First of all, the pre-sentence report is prepared by a probation officer. Now, not all states use pre-sentence reports, but the federal system does in fact use a pre-sentence report. So the pre-sentence report is ordered after sentencing, and it's prepared. You usually get about 30 days, 60 days max to prepare your report, and then the judge uses it for sentencing. So prosecutors, defense attorneys, parole boards, probation departments, prisons, jails, all use the information in the pre-sentence report for something or another. And I'll go over a little bit about that too. So what does the pre-sentence report contain? It contains information about the offense, about the offender, about sentencing options, and so on. Now, the probation officer does a recommendation, and believe it or not, the judges tend to accept the probation officer's recommendation anywhere from 72 to 90% of the time. So being a probation officer holds a tremendous amount of responsibility. So you hold somebody's freedom in your hands. So it's not a job to be taken lightly. There it goes. So what's in the contents of the pre-sentence report specifically? We talk about the offense conduct. So you specifically state the exact charge and what the offender's role was. You want to talk about if there was a firearm involved. Criminal history is a very important component of the pre-sentence report. See, prisons use the pre-sentence report to determine initial classification, and community corrections programs and so on, like probation, day reporting centers, residential treatment facilities, residential confinement facilities, all use information from the pre-sentence report to determine security and classification. So how do you do a pre-sentence report? Well, let me tell you a story, just a brief story about my practical experience, my first pre-sentence report when I was a probation officer. So I had a couple, I was doing a federal pre-sentence report on a couple named the Gibsons. And so the very first report I do, I go to their house to conduct an interview, and that's what happens. Walk into the house, and I'm all, I have heels on, dressed and whatever for the job. And the first room I enter is a dirt floor. So I have to walk across the dirt floor, and there's just bugs and everything in the house. So an unwritten rule is, you don't really want to sit on an offender's furniture when you're out there doing community supervision. So oddly enough, I did my first pre-sentence report on that couple, and they were also my first supervision case as well. So you go to their place, or they come to your office, and you do an interview. Based on the information that you obtain from your interview and the information you obtain from arrest reports and things like that, you start your independent investigation. And that's what a pre-sentence report is, pre-sentence report investigation. It's an independent investigation. So you can't just go on what some law enforcement officer talks about in their report. You have to verify that information. You have to dig a little bit deeper. So what you're going to do is you're going to do collateral contacts and collateral interviews. If an offender reports to you that they dropped out of high school, then you have to go and verify that that offender dropped out of high school, which means you do a collateral request for educational records. You also look into employment history. Yes, that means you have to contact employers that they allege that they worked for. So it's all about investigation and verification. Then you do an evaluation summary, and you talk a little bit about the viability of sentencing for your offender. In other words, you don't want to recommend an offender get community corrections, number one, if they're not statutorily eligible for community corrections. That means you have to look at the law. If sometimes the law, statute, will preclude certain types of crimes from having a community sentence. So that's your job as a probation officer or a community corrections officer to verify the eligibility of that offender. Secondly, you want to make sure in your recommendation that whatever you recommend in sentencing actually exists in the community. For example, if you recommend that you want your offender to do 90 days on home confinement, well, you better make sure they have a home, because I'll tell you this story. As I was doing a revocation case one time on an offender on supervised release, and the judge actually sentenced my offender to 90 days home confinement, which normally wouldn't be a problem, right? Except for the fact that I told this judge that my offender was in fact homeless. So the judge, in his infinite wisdom, sentenced a homeless person to home confinement. So what do you do with that as a community corrections officer? You just make sure they report to you, and you have to get up, get out of the office, and go check on them a lot. So make sure something exists. For example, we have a lot of problems with drugs with our offenders. You're looking at half the federal inmates are there for drugs, and about 40% of state inmates are in there for drugs, and probably 70% to 80 to 90% of people on community corrections are there because of drugs, right? So drug treatment is going to be something you need to look into in the future, and make sure you know about treatment resources in your area. I mean, I'm talking about intensive inpatient treatment, intensive outpatient treatment, residential treatment for drug offenses or for drug addiction. Then you want to look at things like, is AA, NA available in your area? Is there individual counseling available in your area? Another thing to really look into is indigent services. I mean, indigent means that people can't afford it, so what do? I don't know about you, but I don't know of any hospitals who are willing to say, hey, come on over, all of our services are free, we want you here because we don't get any money from you. No, normally they want people with insurance that can pay that. Well, our caseloads, many of our people aren't going to have great insurance to pay for substance abuse treatment. So you got to be able to be aware of facilities in your area that have indigent beds that are willing to take people that can't pay for their treatment. One of the big things that we like to include, or that sometimes, well, federally it's mandated that you have to include this. It's called a victim impact statement. And even if you're not required to put it in, I strongly suggest putting it in, because I'm a huge advocate for victims. Victims are basically what we need to look at in our system. It's called the criminal justice system, but it should be called the victim justice system, in my opinion. But that's just my humble opinion. So the federal law mandates that all pre-sentence reports have to have a victim impact statement. So we have to look at harm done to the victim. We're looking at psychological harm, financial harm, things like that. Did the victim miss work because of the crime? Did the victim have to get child care to be able to go and testify in court? You want to look at costs like that. Now, one thing you have to consider too is that if, let's say, there's property damage and your victim has insurance. So the way to calculate that is that you want to request or recommend restitution from the offender. So you want to split your restitution and have the offender pay restitution to the victim for whatever their deductible was for their insurance, and then go ahead and pay restitution to the insurance company to cover the costs of the loss. Okay, so that being said, we talked a little bit about pre-sentence reports. Let me move on to conditions of supervision, because when you're doing your pre-sentence report, you also have to make recommendations on any kind of special supervision conditions you want that offender to have. So we have standard conditions, and then we have special conditions. Some standard conditions, some examples would be like random drug testing. The offender has to keep a job. The offender has to report to the probation officer as directed. That's right, you get to tell that offender when they need to report to you or not. They have to file monthly reports. They can't associate with any other criminals. And those are just, a couple examples. So here's some examples of special conditions. The thing to be concerned about as a professional when you're recommending special conditions, they have to be constitutional. You can't just go crazy and be like, no, I want this offender to report to me 3 times a day. You know, you have to make sure they're viable special conditions. So first of all, they have to be constitutionally sound. And second of all, they have to be actually related to the offender's needs or risks, which we'll talk about in chapters to come. Here's an example of a special condition, something like the offender must pay must obtain their GED, or the offender must pay restitution, or the offender must pay child support, things like that. So let's talk a little bit about pretrial release, because this is part of the chapter. I just want to briefly touch on it. Pretrial release is release before the offender goes to trial. Now, sometimes they're supervised, sometimes they are not. In the federal system, there's a whole division called pretrial services. And a lot of times states just release people on bail and let them, come back to court on their own and hope that they appear. Basically, that's all I'm going to talk about today, so thanks for listening.